Good morning, everyone, and welcome to our autumn edition of the On-Site Construction webinar series. So we've got a packed agenda for you today. And before I begin, I'd just like to go through a few housekeeping points. So all microphones and videos have been disabled and they'll remain disabled for the duration of the webinar. The webinar will last no longer than an hour and it's being recorded. Questions are encouraged. So as we go through the presentations today, please think of any points you want to ask our panelists. Without further ado, I'd like to hand over to our first presenter, partner Ryland, who will be speaking with us with guest presenters from Alvarez and Marsal.
Thank you very much, Barry. Good morning, everyone, and welcome. So today's topic for discussion is the Holy Trinity of risk management, and hopefully I'll be able to bring some morning glory to your day. In my view, the key to a successful project in terms of risk management, it is all about the team. It's about the contract, it's about time, and it's about money. They are the key pillars that maintain a successful project. So how does this work? Well, in my view, I've created what I like to describe as a project counsel role, which we often use for clients, whether that be employers or contractors or subcontractors on projects. And what that team does is it pulls together those pillars behind the scenes to manage that risk properly. And I think this is incredibly important at this point in the construction industry because it faces big challenges. As many of you will know, we have the recent collapse of ISG, very large main contractor in the UK and other markets. And it's understood that that has left around £700 million in debt throughout its supply chain. And it begs the question, how did this happen? I understand that many of its suppliers and subcontractors and contractors below it are owed millions of pounds. But how does it happen? How do things get to that point? How does it slide away from parties involved in that supply chain? Well, in my view, it's a failure to mitigate risk on three fronts. Throughout the contract, that starts with the drafting. We can advise on the preparation of contract documents. We can advise at the review stage, and we can advise on the operational side. Secondly, delay equals money. And delay analysis is so often left until after the event, which makes it more convoluted, more difficult, and more expensive. And then thirdly, the effect has to be properly analysed and properly presented by way of quantum. And that is why today's offering in terms of training includes my two guest speakers, Katostaras and Andrew Drennan of Alvarez and Marsal, who will follow. Now, the reason why this is so important is because clients, I believe, are often too reactive. They act after the event, which prevents avoidance strategies. And obviously, when you're looking at things retrospectively, fact gathering, document gathering, and that's often after certain staff have moved on, is difficult and expensive. As project counsel, what we will do is we will be proactive. We'll act behind the scenes, provide holistic legal support throughout the lifespan of the project. And that will include what we describe as regular health checks. And they can deal with all kinds of payment processes, looking at entitlement to smash and grab or true value claims, considering the delays and the programs with the support of delay analysts, comparing budget versus expenditure, and then obviously, if necessary, looking at defences and claims. So to put this all into context, I've come up with the idea of Project X. And this is a theoretical project where a hospital is being delivered by our client, in this case, ABC Contracting. And they are doing this project for a local authority who I'm calling London County Council. As part of this project, I'm imagining that there is a short stay paediatric area, a care for elderly ward, a speculative palliative care unit, and a stroke and rehabilitation ward. So there are essentially 4 sections. And the contract is based upon the Design and Build 2024 JCT form. The contract sum is 40 million, and those 4 sections have sectional completion dates. Now, in the specification for this hospital project, there is a requirement for a standard airflow rate in the air handling units to be installed. The works commenced on or around the 1st of August this year, and subsequent to that, there was an instruction received from the client to increase the airflow rate by 4 times. And that obviously raises the question, is that a change to the scope? So the first issue is, what was the original scope? What was contained within the employer's requirements and contractors' proposals? And does this in fact represent a change? Sometimes under the design and build contract, things like this and instructions may not necessarily represent changes because they may be necessary to comply with the original employer's requirement. They may be part of what's called design development, for which the contractor has already priced. In this case, the specification was clear, and this is a change to the scope. What that means under the contract is that it's both a relevant event and a relevant matter. So let's have a look at what they mean. A relevant event is an event that can give rise to an extension of time for the works. And the events include changes, as I've listed here, but they also include a number of other issues or events that can arise and give rise to a claim. The next thing to look at, often behind the scenes, is to ensure that the contractor has followed the process in the contract. And I've set out here clause 224, which is very clear about when and how a contractor should give notice of its entitlement. Now, what I would say about notices is it's important to issue notices in relation to any issue that you think may impact upon the completion date. But of course, if you haven't analysed the programme properly, it's difficult or sometimes impossible to know whether that event in fact has an impact. And Harris will say more about that in due course. But the process is set out here. If and whenever it becomes reasonably apparent that the progress of the works is being or is likely to be, so this is something that could have happened or is likely to happen, you forthwith give notice with the material circumstances. And then it goes on, in respect of each event, the contractor shall, if practical, in the notice or afterwards, give particulars. So those particulars need to be clearly based upon entitlement, which of course comes from, the origin is within the instruction and the effect of that on the programme, which is obviously a planning issue. Then it goes on, the contractor shall forthwith notify of any material change in the estimated delay, because of course programmes are shifted, items are resequenced, so this is an ongoing duty. And then if on receiving the particulars or any notification, the employer requires such further information, they should request that information no later than 14 days from receipt. So it's important now under the JCT, which it wasn't specific about previously, that you keep an eye on those timeframes and keep the pressure on an employer to make an assessment. So essentially, your entitlement is based upon, in the notice, what the event was. Does it qualify as a relevant event? And if you've qualified and you've issued notices in accordance with the contract, there's then an obligation, and only then an obligation, on the employer to fix an extension of time, which is fair and reasonable. And of course, that may be a question of dispute if you have an entitlement which is not fairly or reasonably assessed. But that decision will be notified to the contractor as soon as reasonably practicable, and not later than 8 weeks from the later of the date of receipt of the particulars or the notice or the date of further information. So again, another time period to stay on top of. So that's time. And as I say, Harris will talk more about that. And then we move on to loss and expense, which will be covered in more detail by Andrew. But the starting point is, well, what is my entitlement under the contract? The grounds include changes, which I've mentioned in this Project X case is then covered. But it also covers a number of other events. You'll notice that this list is shorter than the relevant event list. That means that there are more grounds to claim extra time than there are for money. And it also means that some delay events are what I'd call cost neutral. In other words, you don't get any money, but you get time. But what's really important here on the contract side of things is to look at the wording of the notification provisions for loss and expense. In accordance with clause 419, if the contractor incurs or is likely to incur any direct loss and expense as a result of deferment of possession or something that interrupts the regular progress of the works materially, then you're entitled to loss and expense, but only if you comply with clause 420. And clause 420 is quite prescriptive. It says that you shall notify as soon as the likely effect of the relevant matter on regular progress becomes apparent. And of course, that's a question of factual analysis, it's a question of delay analysis, and it's also a question, of course, of quantum analysis. What you then do as the contractor is you provide an initial assessment. Now, I don't think it's reasonable to expect a general professional team to necessarily know exactly what's to be included in this initial assessment. And sometimes it will require input from an independent or a separate project counsel advisor in relation to quantum to say what they expect to see in that assessment. And it's also a question of legal analysis as to what you're entitled to as a matter of law. There's then an obligation to follow up on monthly intervals. And then within 28 days of the initial assessment and 14 days of subsequent updates, the employer should then assess this entitlement in sufficient detail to allow you to assess whether or not it's reasonable and what the differences are. So there are obligations on both sides, and there's also a time frame for the response, which again you have to keep an eye on. So in short, what do you do and how do you manage this? Well, you can't just roll with it. What you need to do is to prevent any sliding away of entitlement. What you need to do is stay on top of things. In respect of extensions of time, delay analysis has to be part of the decision as to whether you bring a claim and to what extent you're entitled to an extension. Programs will need to be provided and analysed for support of the cause and effect. You need to test the underlying evidence. And if you do that and you plug in an expert team, such as the guest speakers today, they will be ready and able to deal with the dispute quickly so that things don't run away with you. And the same applies to loss and expense. So on that basis, and without further ado, I will hand over to Harris, who's going to talk a little bit more about Project X and its impact in relation to delay. Thank you.
Thank you very much, Ryland. Good morning, everyone. I'm Harris Katostaras, and I'm a senior director and a construction delay expert at Alvarez and Marsal. Today, I will discuss the importance of regular health checks and how they can be implemented in Project X, which Ryland introduced earlier. I will also outline the steps the project team should take to investigate the potential impact of the airflow change on the project's timeline. And finally, I will refer to issues that we should consider while preparing loss and expense claims related to delay issues. As Ryland mentioned above, Project X is a hospital project delivered by ABC Contracting. The contractor has established a procedure of conducting monthly health checks. Further, they decided to schedule the health check for the second week of each month following the issuance of the monthly progress report. The first step is to check the program. Project X has 4 sectional completion dates, and therefore I would expect that apart from the program describing the works overall, there should be separate programs describing each sections. In terms of program health checks, the contractor regularly should review the project's program to identify any deviations from the original plan. However, before addressing deviations and delay issues, the first consideration should be whether the current program accurately represents the actual progress of the works. While this may seem straightforward, often programs either fail to demonstrate the actual progress of the works or do not accurately depict the critical path. If the program is not representative, it becomes challenging to see if the project is in delay and subsequently to measure delays accurately. So for health checks, the contractor should ensure that they are not undermining themselves by presenting non-representative programs. It is crucial because we often encounter programs submitted to clients with numerous deficiencies, such as missing activities, missing links, or even manipulated programs. When conducting a health check, it is essential to ensure that the provided program reflects the actual progress of the works. Now, once a reliable program is established, the contractor can proceed to assess whether the project is in critical delay. If the project is in critical delay, accurately assessing the extent of this delay is crucial, as it will subsequently impact loss and expense claims. It is also important to note that there is not just one type of critical delay. There can be actual critical delay, which is a delay that has occurred and is affecting project completion, and forecast future critical delay, which is a delay that has not yet occurred but is anticipated to happen and is expected to affect the critical path if no mitigation measures are taken. During the health check, there should be a clear understanding of this distinction, and the contractor should assess the extent of both actual and forecast critical delays. The third point is assessing non-critical delays. Evaluating non-critical delays through program reviews is not at all straightforward. The programs must again be reliable to allow us to determine whether there have been delays in non-critical sequences. Why to assess non-critical delays? Firstly, because an event can cause a non-critical delay that should be considered for a potential claim, and B, because work sequences that accumulate non-critical delays may become critical over time. Therefore, it is really important to have a thorough understanding of these non-critical delays. Another critical aspect of health checks is the consideration of variation orders and their impact on the critical path of the works. Understanding whether these VOs affect the critical path is essential for accurate delay assessment and subsequently issuance of any claim. Similarly, understanding how these VOs impact the non-critical sequences is equally important for the reasons previously explained. During health checks, there should be a review of the programs before and after the impact of the variation orders, and the forecast durations of the VOs should be reasonable and based on actual and historical data to avoid overestimating or underestimating their potential impact on the project's timeline. Finally, the program should be well structured, with activities related to the VOs linked to the specific activities they affect, rather than to general activities. For example, we often see misrepresentations of VOs in programs, such as VO affecting the fit-out works on one floor being incorrectly linked to the overall fit-out works. And this misrepresentation can lead to inaccurate assessments of the critical path. Another point that should be considered during health check is any resequencing of works. Resequencing often indicates the contractor's inability to progress as per the original plan. Common causes include incomplete design, underground obstructions, or late handover of parts of the work from the client. While resequencing doesn't necessarily mean that delays will occur, it should raise an alarm during health checks, as it can potentially lead to delays. Finally, an important task during health check is to thoroughly review of the extension of time and disruption claims prepared for submissions. Additionally, it is crucial to review the client's responses to the delay-related claims and prepare a strategic plan to address any issues raised. In relation to risk assessment during the health checks, there should be continuous evaluation of potential risks. Considering all the above, we can now return to the relevant event, the instruction to increase the flow rates of the air handling units in our hospital project X, and assess the impact of this event may have on the project timeline. The top figure demonstrates the program of the works before the event, before the new instruction. Although this is a simplified program, it will help us discuss certain aspects for the sake of argument. For simplicity, I will only show the mechanical and electrical works in this figure. We can see that before the event, the mechanical sequence of the works was driving the start of the commissioning works. Further, the mechanical sequence was on the project's critical path since it was driving the project's completion date. The bottom figure demonstrates the program after the new instruction. It is evident that the new instruction, due to the additional procurement period, will cause the project's completion date to be pushed to a later date. Therefore, the contractor, depending on the contract particulars, may be able to claim an extension of time. This issue should be identified during the health checks and escalated so that the claim can be prepared. Specifically, a delay analysis is required to notify the likely impact of the event, and associated documentation is also needed to support the cause and effect. Of course, this was a relatively simple example, but during health checks, it is certain that more complex issues will arise. For instance, consider that in addition to the airflow change, there was another delay impacting the electrical works for which the contractor was responsible. If this delay also pushed the project's completion date to a later date, would this mean that the contractor is still entitled to an EOT due to the airflow issue? And if so, under what circumstances? So even though I will not discuss this specific issue now, it is clear that there are other more complex issues that often appear and affect loss and expense claims. In this slide, I have gathered the different circumstances under which the contractor may claim loss and expense related to delays. Firstly, as explained in the airflow example, the contractor can often claim loss and expense for critical delays if they are caused by events for which the client is responsible, such as late instruction, design changes, or other client-related issues. Regarding non-critical delays, contractors may be able to claim loss and expense for these costs if the contract allows and if they can demonstrate that the delay caused additional expenses. Additionally, other circumstances should be considered, such as disruption, that if it causes inefficiencies and additional costs, even without affecting the critical path. Acceleration, if the contractor is required to accelerate work to overcome delays, often at the client's request. Concurrent delays, which is a very complex issue, and the ability to claim loss and expense depends on the contract terms and jurisdictional rules. And force majeure events, although these typically provide relief from penalties rather than compensation or additional costs. And finally, to reiterate, the contract is the king. The specific terms of the contract will dictate the circumstances under which loss and expense can be claimed. And regardless of the type of delay, contractors must provide detailed documentation to support their claims, including records of the delay impact and the additional cost incurred. Thank you for your attention. I will now hand over to Andrew Drennan.
Thank you, Hannes. Yeah, hi, I'm Andrew Drennan. I lead the construction practice for Alvarez and Marsal. I'm a practicing quantum expert and a quantity surveyor by background. Next slide, please. I'm going to give a bit of an overview in terms of three key principles, actually, in terms of prevention, monitoring, and valuation. Some might say this is the circle of trust. I like to look at this as basically from inception to completion. So take the inception part. We've got Ryland and the team have reviewed the contract or drafted the contract. We've got a scope. We've got a schedule, risk, and price. Effectively, at the inception point, we want to make sure that that program and price effectively match the scope and adhere to the contract terms. Within that check, we'll be looking at things like other project resources and capabilities capable of delivering that scope and program. Do the contract team, do the project team, do they have an awareness of the component parts of that project? Also in terms of that scope. Do the systems and processes, do they align with that scope? Can they adhere to the program and price requirements? And then most importantly, are the vendors, suppliers, subcontractors, are they also back to back with those contract, scope, program, and price requirements? Talking about Project X, for example, we spoke about that key consideration in terms of the air handling unit change. So in that simple circle of trust, we've had a change to the scope. We've shown by Harris's example, we've got a change to the program. That's effectively changed the risk profile and effectively the price. So I'll come on to that and how we handle that a bit later. Next slide, please. On an interim basis, as a QS, obviously our responsibility is to do the valuation, not only of loss and expense, but on a monthly valuation process. I think this is quite a good example of basic communication and good practice. Now, in any dispute, communication is probably sadly lacking, right? So what we want to do in terms of that health check, we don't want to give clients or suppliers any surprises. So in doing that, what we want to be doing is on a monthly basis, treat interim valuations or indeed subcontractor assessments. We want to treat that as a monthly final account. What that means is we want to value everything appropriately in terms of that monthly progress. We want to agree variations. And effectively that leads up to a final account in which one of my key things is engaging with clients or subcontractors to purely communicate the position on each item. Most importantly, we need to ensure that the final account statement is substantiated, critical in terms of loss and expense, that these are validated and substantiated. And I'm going to come on to that next. Next slide, please. So if we take that example that we talked about in Project X, these are again three key principles in terms of those quantum calculations. Firstly, can the cost be demonstrated as being incurred? Now that sounds quite simple, but when we're looking at a very first point in that analysis, whether it's a dispute or whether that's a loss and expense claim, we need a robust set of records. So we need to establish the actual costs that has been incurred in relation to each item. So that records a granular detail of what happened, when it happened, why and where on site. The next point up is, are those costs reasonable? Now, back to the example in Project X, we're talking about an air handling unit, right? So did we procure that item appropriately? So if we're in a loss and expense situation, did we go to 3 suppliers, for example, to get reasonable prices for that air handling unit? Is it competitive in line with market prices? These things should all be checked as part of that process. And then finally, are those costs incurred in relation to the event claimed? Now, this is where it becomes a little bit more complex and again relies on the granularity of how you allocate those costs. Harris spoke about the impacts. So we could be looking at quite a simple change in an air handling unit, which involves multiple things. So we spoke about the mechanical design, procurement activity, installation, commissioning, and of course there's a direct cost of the handling unit itself. And then the impact of all these things is not only a delay and additional direct costs, but potentially that has consequences of prolongation. That affects management team, prelims, and all these things in terms of that loss and expense, or indeed in a formal dispute situation, we need to effectively allocate those costs to the specific event. Thank you for listening. I'm going to pass on to Jack next. Thanks very much.
Thanks very much, Andrew. Good morning, everyone. My name is Jack Moulder, and I'm a senior associate in the dispute resolution team at Watson, Farley and Williams in London. So today I'm going to talk to you about a recent case, which is very significant for the industry. That is the Court of Appeal's decision in Providence and Hexagon. So the judgment was handed down about 6 weeks ago, and it's a stark warning to employers about the risks of repeating a specified default under the JCT forms. The talk's called No Third Strike for Late Payment because the Court of Appeal found that repeated late payments gave the contractor the right to terminate immediately, even where those late payments were subsequently remedied within 28 days of a notice of specified default. So the significance is obvious. As an employer under JCT contracts, if you pay late repeatedly, you run the risk that your contractor may be able to walk away. So I'm going to talk a bit about the case itself first, and then I'll come on to briefly discuss what can be done about it. So first, just a bit about the contract in the case. The parties had entered into a contract on the JCT 2016 design and build form with Hexagon as employer and Providence as contractor. As you probably know, the 2016 design and build allows the contractor to terminate for specified defaults if they either go unremedied for over 14 days after a notice of specified default. That's clause 8.9.3. And note that period was actually amended to 28 days in the Hexagon contract, or if the specified default is repeated, and that's clause 8.9.4. And one of those potential specified defaults is a failure to pay by the final date for payment. Note that the same wording also appears in the standard building contract, and the wording hasn't changed in the 2024 suite. So this issue isn't necessarily confined just to the 2016 design and build form. So what happened in this case was that Hexagon failed to pay payment application 27 by the final date for payment. So Providence served a notice of specified default, and Hexagon then paid in full within 28 days of that notice. So the right to terminate under clause 8.9.3 never arose. Then a few payment cycles later, Hexagon missed the final date for payment again, and the following day, Providence issued a notice of termination under clause 8.9.4. And Hexagon then paid the relevant application in full a few days later again. Then a dispute arose as to whether or not Providence had the right to terminate under 8.9.4 in circumstances where the right to terminate under 8.9.3 had never arisen. So just to explain a bit further about these subclauses, under 8.9.3, where a specified default has occurred, the contractor can issue a notice of specified default wait 28 days under the Hexagon contract, 14 days under the unamended form. And if it hasn't been remedied within that period, then the contractor can terminate immediately by issuing a further notice. Under 8.9.4, where the contractor hasn't served that further notice to terminate, but the specified default is repeated, the contractor can terminate for that repeated breach. The core question for the court was this: do the words "does not give the further notice" in clause 8.9.4, which are highlighted in red on the slide there, cover any situation where the contractor does not give that notice, even if the reason is that it never had the right to do so? Neither the adjudicator nor the TCC at first instance thought so. They both sided with Hexagon that the right to give that further notice under 8.9.3 needed to have arisen but not been exercised. But the Court of Appeal disagreed. Court of Appeal started by considering the ordinary meaning of the words used in 8.9.4 itself. And on that point, it said, viewed in isolation, the natural meaning of the conditional words at the commencement of clause 8.9.4 are clear. The words, if the contractor does not give the further notice referred to in 8.9.3, are broad enough to cover any state of affairs, other than one where the contractor does give notice. And then it went on to consider some other angles as to whether there were any compelling reasons to depart from that preliminary view based on 8.9.4's ordinary meaning. So first, reading the contract as a whole, the court asked itself whether there was a sufficient linkage between 8.9.3 and 8.9.4 so as to imply that 8.9.4 means if the contractor had or has an accrued right to, but does not give the further notice under 8.9.3. But the only factors it saw as speaking in favor of that were, first, the placement of the clauses within the contract and the word "the" in the phrase "the further notice." And it didn't consider either of those factors sufficient to support a departure from what it saw as the clear meaning of 8.9.4 viewed in isolation. It then went to consider the commercial consequences of its view as to what 8.9.4 meant. On either view, the Court of Appeal said the commercial purpose of the clause is the same, which is to encourage the party concerned to comply with its contractual obligations, and a repetition of a previous specified default is the trigger to entitling the wronged party to terminate. It also observed that, all else being equal, similarly drafted clauses should be interpreted in a consistent way. So it noted that another clause, 8.4.3, which is about the situation in which the employer can terminate, was structurally similar to 8.9.4. But whereas 8.9.4 used the words "for any reason," 8.4.3 used the narrower phrase "whether as a result of the ending of any specified default or otherwise." So 8.4.3 specifically included a situation where the specified default was remedied, and the Court of Appeal then reasoned that the words "for any reason" in 8.9.4 were at least as broad as that. So logically, it said 8.9.4 also had to cover a situation where the further notice hadn't been given because the specified default was remedied in time. So the court concluded that Providence was within its rights to terminate under 8.9.4, even though Hexagon had never exceeded the time limit for remedying a specified default under 8.9.3. Quite a draconian result for the employer, arguably. Effectively, 2 late payments, where there's been given a notice of specified default, is enough for the contractor to terminate. So what does this mean for contracting parties? If you're contracting under JCT terms and this provision remains in your contracts, repeating specified defaults leaves you open to a risk of termination. Looking at it from the other perspective, the contractor's perspective, it provides the potential for a contractor to escape from contracts where it's consistently being paid late, or there's some other repetition of specified defaults. And as I've mentioned earlier on, though the 2024 JCT forms haven't been tested to my knowledge, the same wording remains. So it stands to reason that they're likely to be interpreted in the same way. So what can you do? Paying parties, so employers, will need to check their contracts to see if they contain these provisions. Be on top of your final dates for payment and ensure you pay on time every time. And for new contracts, consider amending 8.9. So you could add, for example, a grace period after a notice of specified default before a repeated default will give rise to a right to terminate. Or you could expressly draft in that a termination right will only arise under 8.9.4, where 8.9.3 right to terminate has already accrued, i.e. the reading that Hexagon was arguing for in this case. For payees, so contractors, don't overlook your entitlements to issue a notice of specified default, as this case demonstrates they're a powerful tool potentially. However, be aware that the JCT forms do provide that notices of termination of the contractor's employment should not be given unreasonably or vexatiously. That's clause 8.2.1. So you do need to be careful. Thank you very much. I'm now going to hand over to Alex.
Thank you, Jack, and good morning, everyone. My name is Alex Mulroney, and I'm a senior associate in WFW's dispute resolution team in London. So today I'm going to talk to you about remediation contribution orders, which is a new remedy introduced by the Building Safety Act. The topics that I'll be covering are what are remediation contribution orders, or RCOs, the applicants who can bring a claim for an RCO and the respondents that a claim can be brought against, the other criteria that needs to be satisfied, the jurisdiction and scope for the property tribunals when they're making such an order, and then I'll finalize my talk with a few take-homes for you. So, remediation contribution orders. The Building Safety Act introduced two really important key remedies when looking at building safety works and the costs arising from them. The first was a remediation order, which is concerned about forcing an individual to complete necessary safety works. And then the second, an RCO, is concerned about who foots the bill, who's responsible for paying for certain remediation works. And that's what I'm going to be talking to you about today. It's an entirely new regime. So previously we would look at leases for the building and other contracts in relation to responsibilities. But RCOs now, if the grounds are met, you can completely rip up those documents in certain cases. Remediation contribution orders are covered in Part 5 of the Building Safety Act. I've included the legislation there on the slide for you, and you'll see I've emphasised the key points that need to be established before a claim can be made out. And that's that we need an interested person, a relevant building, and then if the tribunal considers it to be just and equitable, it will make an RCO against a specified body, corporate or partnership in relation to costs that have been incurred or are going to be incurred for remedying relevant defects. And so I'll now take us through each of those in a little bit more detail. Interested persons under the Building Safety Act, that's your applicants that can bring a claim for an RCO in the first tier tribunal. And so here we're dealing with people with a legal or equitable interest in the relevant building that's impacted, or we're dealing with authorities such as the Secretary of State, the building safety regulator, local authority, or the fire and rescue authority. And as you'll see, given that it was rapid legislation that was brought into place, they also included power for the Secretary of State to allow new applicants to come in the future. It's also important to note that the government has issued guidance about how authorities should be pursuing RCO claims. I've included a link on the slide, but essentially there should be a coordinated approach if two or more authorities intend to bring an action. The respondents to an RCO, those who can be forced to pay for the building safety works, are the specified body corporate or partnership. And that's defined as a landlord under the lease, lease of the building or part of the building, but also those who are landlords at the qualifying time. And the reason for that is everyone was anticipating the Building Safety Act coming into force. And so the government didn't want unscrupulous landlords quickly selling off their interests so that they couldn't be pursued for an RCO. And interestingly, the government decided that Valentine's Day on 2022 should be the appropriate date for looking at. We're also interested in developers of the building, of course, and then entities that are associated with those landlords and developers. And there are also additional rules for dealing with insolvent landlords. Again, those are anti-avoidance measures. But it's not always that simple. You can't bring a claim for an RCO against individuals, natural persons, and we assume that that's because it could raise human rights issues. It's also very unclear on whether an RCO claim against a right to manage company would work. The government's issued lots of detailed guidance, but it hasn't been able to address that point with any certainty. And then there are different rules to navigate when dealing with essentially resident-owned entities, such as common hold associations and majority-owned landlords. Moving on, once you've established you have an appropriate applicant and respondent, it's necessary to ensure that you have a relevant building for an RCO. And it's important to note at the outset that whilst there's a measurement test here, the test is not the same as the test used for whether you have a higher risk building that requires registration. Here we're looking at self-contained buildings or parts of self-contained buildings that are at least 11 meters high or have at least 5 stories. And again, there are exceptions for resident-owned entities. So what does self-contained mean? Well, if the building itself is structurally detached, that's very simple. It's a self-contained building. But for part of a self-contained building, it's necessary to establish that it's capable of vertical division, it can be independently developed, and that relevant services are or could be provided to it without significant interruption to the rest of the building that it's adjoined to. And those with background knowledge of enfranchisement legislation will note that the Building Safety Act's test for that is essentially a verbatim copy and paste of the Common Hold and Leasehold Reform Act and other enfranchisement legislation. So proving that you have a relevant building, that can sometimes be quite difficult, particularly in areas such as London, where you have unusual developments. But you can look at expert evidence from surveyors or engineers to help with that. There may also be documentary evidence, such as FRAs or surveys of the external wall system. And as I say, the legislation is a copy and paste from enfranchisement cases. So there may be some useful tribunal judgments from the past that you could compare to your scenario, in addition to looking at available planning documents, and for very complex cases, possibly enlisting the help of a local historian. I've also noted disclosure orders. If you know or suspect that relevant documents are out there, but you don't have possession of them, Disclosure in the first tier tribunal is quite rare in contested claims, but it is indeed possible. Now that we've established we have a relevant applicant and respondent and the building qualifies for an RCO, we need to establish that there's a relevant defect that's going to cost money that we need to pursue. And so a relevant defect is one that's described as a defect caused by something done or not done, because of anything used or not used in connection with relevant works, which causes a building safety risk. And relevant works and building safety risk are then defined as well. So for relevant works, you're looking at works to construct or convert for partial or whole residential use. Then it has to have happened. Those construction works need to have happened within the relevant period, which is 30 years ending on when this section of the Act came into force, 28th of June 1992 until the 28th of June 2022. If your works fall within that period, you may be entitled to an RCO. And again, building safety risk, that's defined. Most people look at an RCO and think that it's only about defects that cause a fire risk, such as cladding or cavity barriers, but that's not actually the case. It can also deal with works required to prevent partial or full collapse. It's then necessary to look at whether the tribunal has jurisdiction to make an order. And for that, they ask the question of whether it's just and equitable for an RCO to be made against someone. There's no guidance for the first tier tribunal in the Building Safety Act for this, so they have an incredibly broad discretion, particularly where the limited case law that we have is making its way through the appeal courts. But there are some good takeaways that we have from existing case law. You can have an RCO in place even if there's a works contract there already to deal with doing works and paying for it, just in case things go wrong and you need the backstop of a tribunal order. It's also very important to note that an RCO is not fault-based. You don't need to show that a respondent was at fault for a remedy to be made. The theme, the thrust of the Building Safety Act is that leaseholders shouldn't be left to foot the bill. And so the tribunal will look to developers and landlords who are thought to have broader shoulders. Beware of the views from civil servants. There's tribunal authority to say that just because a civil servant takes an interpretation of the Building Safety Act doesn't mean it's going to hold any evidential weight. The tribunal accepts that civil servants can sometimes get things wrong. But other than that, it's important to really note the first tier tribunal, it's designed and operates as such a practical forum. But it's very different to normal TCC type claims that you may be used to in construction disputes. Firstly, it's generally a cost neutral environment. So even if you're successful in your claim, you usually wouldn't have your costs awarded to you. But there are some exceptions to this, such as pursuing Section 20C orders, orders for your costs based on one party being particularly vexatious or unreasonable during the litigation. When looking at whether something's just or equitable, the tribunal can also deal with RCOs retrospectively. They can do it for works or costs arising that happened before the Act came into force. And that's really rare in new laws. It's very rare that something would be retrospective in effect. And as I say in my slide, it's also worth thinking about RCOs strategically, because you can pursue them even though other claims are viable, and you may want to try them with a few different claims strategically. So when we're looking at the just and equitable question, triathlon is still the main authority that we have for this. It was the main detailed case so far, although it is subject to appeal. It's going to the Court of Appeal shortly. When looking at the case, which involved the old Olympic athletes village that required substantial remediation works, the tribunal made an order, but it also used it as an opportunity to decide what were relevant considerations and what were really irrelevant matters to help with future cases. And it's important to note that really the main thing that was relevant for them was the grounds were made out, the grounds that we've just gone through. And one of the respondents was a developer of the site, and another one was associated with it. That was really a powerful thing for the tribunal, which persuaded to make an order. There was building safety funding in place, but the terms of that funding were not entirely settled and may not have covered all of the work. So again, that was quite relevant to them. What had little or no weight was the motivation of the applicant pursuing an RCO. It was a leaseholder of part of the development, but it also had tenants who were social housing tenants. And so there was much in dispute about the motivation of the RCO claim. The applicant said that it needed to regularize the situation for its social housing tenants, but the respondents contended that this was really just a sham excuse that had been invented because the applicant didn't want to pay for anything itself. The tribunal said it didn't pay any attention to that. The motivation of the applicant was irrelevant. Also, one of the respondents itself could have made a claim for an RCO, but decided not to, instead pursuing building safety fund funding. And the tribunal said, well, that doesn't really matter either. This is a self-contained remedy in the Building Safety Act. And just because another party could bring a claim doesn't stop the applicant from doing so. Also, quite importantly, the beneficial owners of the respondents had markedly changed since the initial development of the buildings happened. So the contractual network and those in charge had changed quite significantly, but the tribunal didn't say that carried much weight, nor did it say that the availability of other remedies, such as contractual claims through the supply chain being available, that didn't matter either, because again, it was a self-contained remedy. So a few takeaways from me to round off. It's radical new law, an RCO. There's an incredibly broad jurisdiction for the tribunal, which is still being made out in the judgments. It widens the scope of paying parties that you can look to if you have expensive works and the funding for that hasn't been established. But be aware, it's deceptively complex legislation. Many of the judgments are going through the appeal courts now, and the legislation is also regularly updated and amended. For example, the Leasehold and Freehold Reform Act will make changes to how RCOs can happen in the future. And because of that, and because it's new law, if you're dealing with conveyancing for one of these potentially affected buildings, it can throw up a number of issues, not least insurance risks. But all that said, if used for the correct or relevant case, RCOs can be extremely powerful remedies and probably faster than pursuing individuals through more traditional litigation. Thank you very much for listening. I'll now pass over to Barry again. Thank you.
Thank you very much, Alex, and thanks to Jack, Ryland, Harris, Andrew for your presentations this morning. There's a lot there to think about, and the chat's been very active, but unfortunately, time doesn't permit us to go through all the questions. We will come back to you directly and answer the questions that we've received, and if there are any further questions, please do refer to them in due course in the feedback form. So I'd like to thank you once again for joining us today. The feedback form will follow up together with the presentation and the slide deck. The recording of the webinar will also be available on our on-site YouTube channel. If you've dialed into the webinar, please do email events at wfw.com to say you've attended, and we can also provide a copy of the slide deck directly. Thank you very much for attending. It would be great to meet many of you in person, and in that regard, please do complete the feedback form if you'd be interested in an in-person event, and give an indication of the time slot that would work for you. And if there are any ideas for future presentations, please do let us know. Otherwise, we look forward to seeing you at our next on-site webinar.